Well, good morning, my friends, and welcome back to the Rhine Report and to the Magic Theater for Madmen Only. Yes, that's what we're dealing with. Let's get right to the point this morning with an update on Governor Newsom's request for a TRO against the fascist Trump regime's imposition of National Guard and Marines into and on the streets of LA. The district court judge, Judge Charles Breyer, agreed ultimately with the state of California in a scathing decision, but permitted the fascists to appeal to the Ninth Circuit Court of Appeals by 12 p.m. today. Well, between last night and this morning, and it's now 9:46, they've already done that. And they've drawn a three-judge panel composed of two Trump-appointed judges, and the third, I think, is a judge appointed by Clinton. And they have already ruled to stay the TRO pending a hearing on Tuesday. In my opinion, it's just my opinion, the state of California must now file either an additional motion seeking a full injunction to replace the TRO or arguing for an agreement to the lower court decision and praying for further relief in the form of a permanent injunction against Trump. In any case, the test for obtaining either a TRO or a full injunction is not all that complicated. It's basically a four-pronged test. One, are the applicants, the plaintiffs, reasonably expected to win on the merits of the case? And the answer to this is yes. Trump has clearly misused 10 U.S. 12406, and he has violated the 10th Amendment by usurping California's sovereignty and the control and power of the governor over a state affair. Two, important question: is there irreparable harm being done to the plaintiffs? And for this, let me answer yes. The people of LA are being subjected to the military in their streets with all of the threats that implies, and are under the threat also of loss of their right to protest, freely assemble, express free speech, and petition their government without interference or the fear of military violence. And let me quote from Judge Breyer's decision. What does Judge Breyer have to say in his decision? Well, he says the following, and I'm reading from a partial reading from his decision of 36 pages. Plaintiffs identify two types of harm that they claim to be likely to suffer in the absence of a temporary restraining order. First, they assert that there is a very high risk of substantial civil unrest as a direct result of defendants' inflammatory and confrontational deployment of the military in a large civilian population center. MOT at 16. Second, they contend that the defendants' unlawful federalization of 4,000 California National Guard members diverts necessary state resources from addressing serious problems facing California, such as wildfires and drug trafficking. Point 3 of the balancing test. What are the balancing of interests, and do they favor plaintiffs? And the answer to this is a resounding yes. It costs nothing for the Trump government to withdraw the troops pending a hearing on the merits. And once again, I refer back to the 36-page decision of Judge Breyer. He says, moreover, plaintiffs have shown a likelihood of prevailing in their argument. President Trump's invocation of Section 12406 was in fact not lawful, both exceeding the scope of his authority and violating the 10th Amendment. When plaintiffs establish, quote, a likelihood that defendant's policy violates the U.S. Constitution, plaintiffs have also established that both the public interest and the balance of the equities favor injunctive relief. See Arizona Dream Act Coalition 757 F 3rd at 1069. Defendants are not harmed by, quote, an injunction that merely ends an unlawful practice. Finally, point 4. What is most in the public interest? Answer: the public interests favor each and every other state, including the 21 states that filed an amicus brief, and their citizens, from the terror of the use of military and civilian matters conforming to the law of posse comitatus. Judge Breyer found, accordingly, the court concluded that plaintiffs have demonstrated that the balance of equities tips in their favor and that an injunction restraining the president's use of military force in Los Angeles is in the public interest. Based on the facts and law as discussed in the decision of Judge Breyer, all of the above favor the plaintiff's case for a TRO and indeed further full injunctive relief. Of course, should the three-judge panel agree with the lower court's decision, we know that the Trump Nazi regime will run to the Supreme Court asking for emergency relief in the form of a stay from the now notorious shadow dockets. And given the past history of this corrupt and fascist court, they will probably grant a stay, and the wheel will spin back again to the lower court on remand, so we dance to another delay in justice, which is part of Trump's lifelong playbook, and one that seems to be working quite well. Thanks for watching. Hope you subscribe. Comments, criticism, analysis, it's all there for you. Good day.